Good afternoon. Thank you everyone for joining. We'll get started in just a minute. Today's webinar is Legal Update, the Litigation Landscape for ADA Digital Lawsuits. Hi all, thanks for joining. We are at 12 o'clock. We're going to just give it another minute or so folks can continue to join us. Today's webinar is Legal Update, the Litigation Landscape for ADA Digital Lawsuits. We'll get started in just another minute here. Good afternoon. Thank you everyone for joining us. I'm Bethany Servin, the Marketing Director here at UsableNet. All attendees are muted. If you have a question during this webinar, please send that in via the Q&A window. This webinar does feature live captions, so you'll want to make sure that those are enabled in your Zoom. We are recording today's session and you'll automatically receive an email early next week with that link and a link to download the slides. So again, thank you for joining today. Our webinar is Legal Update, the Litigation Landscape for ADA Digital Lawsuits. I see we do still have some people joining, but we're about 2 minutes past, so we're going to go ahead and get started. It's my pleasure to introduce today's presenters. We have Peter Shapiro, Melissa Doherty, and Jason Taylor from UsableNet. And I'm actually going to go ahead and pass the presentation over to Jason now.
Thank you, Bethany. Thanks everybody for spending a little bit of time with us. I'm really happy to have Peter and Melissa here. Peter practices in New York and Melissa practices in California. So you're going to have access to people that are practicing in the two biggest or hottest areas with regard to ADA legal action right now in terms of geographically. What we're going to do is quickly give you an update of like how we got here. I think it's important to understand, the role of the DOJ in how, in the background with regard to legal cases. Peter's going to talk specifically about a most recent case decision and how that may be or may be not affecting the particular landscape right now with the WinDixie. And then we're going to go into 2 or 3 areas of sort of looking at some of the trends, but also I think it's important to understand things like class action lawsuits, whether you need to worry about those. We're going to look at the lawsuits which are outside of web, so the growing number of mobile and video, and why we believe that's sort of an area that companies should take a look, keep an eye on. And we're going to also talk about like the defense options and sort of the decisions that a company can make if they get some type of legal action. I want to start with a slide, and I'm going to actually pass it over to Melissa to give us some detail. But if we can go to the next slide, please, Bethany. So we want to talk about the background. How do we get here? ADA lawsuits and demand letters are, one of the fastest growing areas of private litigation. I think it's important to understand that this is something that's been going on for a long time, not just in the sort of 3 years that I'd imagine a lot of people have started to get awareness of. There's a chart on this slide. I want to just describe the chart in case some people can't see it. Essentially, the chart maps out the number of lawsuits in this space from the year 2000 through to today. And basically what this chart illustrates is that early on in the 2000 to 2015, the Department of Justice played a very active role on the plaintiff side, helping plaintiffs and joining plaintiffs to push the accessibility and access to key websites and apps. So for example, Bank of America, H&R Block. So essentially in the early days, primarily the lawsuits were being brought by what I would class as advocacy groups. So Federation for the Blind, against an organization that they felt provided a service which was really important to the blind or the disability community, and the Department of Justice joined those cases, also believing that the websites or apps should be accessible. You're going to see that the sort of non-DOJ lawsuits, so brought by private plaintiff firms, essentially was quite low until about 2016, 17. And then since 2017, that's exploded. That's now, 3,000. I think the numbers for this year probably be in the region of 4,000 cases. And I think it would be good for Melissa to give sort of a legal reason why, one, sort of the importance and influence of the DOJ over the years, and then also what was significant about 2017, and why have we seen an explosion since then in terms of cases. So Melissa, if you could take over those two questions, that'd be great.
Sure. Thanks, Jason. So as we all probably know, the ADA has been around for 31 years, but the prosecution of these website related claims, they just weren't making their appearance until 2000. And as you can see, and Jason mentioned, between 2000 and 2015, we weren't seeing private lawsuits. And obviously the drafters of the ADA didn't contemplate what the current state of technology development and the internet would be, given the internet was just in its infancy. But the question became whether or not the intent of Congress was to evolve with the rapidly developing landscape of technology. And I think we would all agree that the answer is yes, but to what extent? And so, as Jason said, we really weren't seeing these private lawsuits until about 2015. And leading up to that, it was the DOJ actions that were primarily resulting in settlements. And then you can see that starting in 2015, we're seeing a trickling of some of these private lawsuits, and the paradigm shifted right at 2017, where there is this explosion. So what happened that year? There were a couple things that happened. First, the DOJ declined to adopt WCAG, Website Content Accessibility Guidelines, which hopefully everybody knows about by now, as the formal regulations. And there was a turn now to the private courts to determine what exactly accessibility meant. And in 2017, we had the Gill versus WinDixie case, which marked the first web accessibility case that was actually tried to verdict. Now, there may have very well been cases that went to trial but didn't actually make it to the end. Gill versus WinDixie did, and then you can see explosion, 2018, 2019, 2020, and on, and we still don't have formal regulations yet. We don't know, are we looking at WCAG 2.0, 2.1? we'll talk about that later. And I think Peter can now talk about WinDixie, what happened in 2017, and what the most recent development is now.
Thanks, Melissa. We're on to the next slide. Some of this, for some of you, this may be old news. For others, it's important to get a handle on this ruling, which some viewed as earth-shaking, but we'll see if that turns out to be the case or not. As Melissa mentioned, it was years ago that this case was tried in 2017, and it was only in April 2021 that the Federal 11th Circuit Court of Appeals issued its decision. And it reversed the trial judge's decision that WinDixie, which, if you're not familiar with them, is a very prominent grocery store chain, supermarket chain in the South, had violated the ADA because their website was not accessible. WinDixie had argued that they didn't need to be fully accessible because they're not an e-commerce site, and the ADA didn't apply because the website was not a place of public accommodation, and a visually impaired person could shop in their stores in the same manner as everybody else, and there was no impact on their ability to do so by virtue of a less than fully accessible website. As may be significant, as I'll explain later, in the interim, an injunction was entered requiring WinDixie to get their website accessible, and that apparently took place. The ADA parameters here were unclear by virtue of other appellate decisions at the time that was rendered. There haven't been too many since, but that's starting to change. But the key takeaway is that the majority opinion on the 11th Circuit ruled that while it couldn't ignore that online inaccessibility is a significant issue for many Americans like Gil, Title III of the ADA is unambiguous in defining public accommodation as limited to actual physical places. As Melissa said, nobody really contemplated the internet as we know it and love it at the time it was adopted in 1990. So the appellate court also rejected the district court's ruling that the website was an intangible barrier to access to the company's products and services. They refused to extend the ADA to the facts presented based on what's set forth in the statute. In particular, they noted the ADA identifies 12 types of covered locations, none of which is an intangible space or place. The public attention paid to this decision may be inappropriately either claiming that doom has struck if you're an advocate for the disabled, or that victory is upon us and you can ignore the ADA if you are a business operating a website. Neither is quite true. First of all, this decision's binding only in the 11th Circuit, which covers only 3 states, Florida, Georgia, and Alabama. In addition, it's seemingly confined to its rather unique facts, which are that WinDixie is not an e-commerce site, and many businesses today are moving to e-commerce, perhaps even more rapidly as a result of the pandemic, because of the prevalence of people wanting to complete their purchases, even for groceries, at home. So it's far from clear that if this had been an e-commerce site, the 11th Circuit would have come down the same way. It's also important to note that there's an effort underway to get the 11th Circuit to change its mind, and that may very well happen. Federal appeals courts usually decide their cases with 3-judge panels, which is what happened here. But you can petition for rehearing by the full court, which has multiple judges. And that's what's been done here by the plaintiff, as supported by various advocacy groups, who petitioned for rehearing. And it seems that the 11th Circuit may be receptive to that because they've asked for briefing on a particular issue. And the key issue there may be whether this claim is moot. If WinDixie has now achieved a compliant website, is there really any need to reverse the decision? It's not really about damages, and arguably it's about attorney's fees at this point. But if the key point of the ruling is that websites have to be compliant, perhaps a company like WinDixie, which now has a compliant website, is no longer in a position to complain that they'll be constrained by virtue of this permanent injunction order. So, and I would also note that the e-commerce aspect of it is confirmed by the approach taken by the Ninth Circuit, another court in a celebrated case, Roblos versus Domino's, which held that because Domino's enables one to order a pizza online, that website needs to be compliant. And it's far from clear that other circuit courts would go the same way as the 11th Circuit did. They may very well go the same way as the Ninth Circuit did. There is a split about whether websites have to be compliant if they're not tied to a place of physical location. That wasn't an issue in WinDixie because obviously they have supermarkets, but that's another issue that we don't know yet how ultimately the courts will come out on that. And we also don't know if that's something that will be addressed by a legislative or an administrative solution via the Department of Justice. And that's something that we can discuss as this webinar continues.
Yeah, Peter, if I could just add what we've seen practically on the ground in terms of lawsuits, and I think that really reflects what you're saying here. Tracking the number of lawsuits, Florida used to be sort of the third largest number of lawsuits every week. That is now sort of trickled down to like 1 or 2, where it used to be like 10 to 15. So we're definitely seeing an effect in terms of reducing numbers in Florida, but we're not seeing a reduction at all in the number of lawsuits in California and New York. And in fact, they're still going up. I think your point about the this is only one particular circuit. I don't think it gives a lot of relief in terms of a company thinking about its strategy around its website and app, and how important accessibility is, because essentially there's not just federal court systems, but also maybe you could talk to the fact that even at California state level, that's a lot more specific in terms of its statute. I think also New York, Peter, at state level, they're a lot more specific about the accessibility. So if you're a company, you operate in multiple states, in some way, you're going to be, you're going to have to adhere to accessibility through either federal or sort of state legislation.
Yeah, I had clients call after hearing about this decision saying, okay, can we now forget about this accessibility nonsense? And I said, absolutely not. And the fact is that, even if you're a business in Florida, if you have sufficient contacts to New York, you may wind up being sued in New York court. New York courts have taken a pretty expansive view of what their jurisdiction is in many cases. And many of the cases that I defend are for companies and universities and other businesses located all around the country. If they have any kind of sufficient connection to New York, which may merely be the fact that they ship goods there that are ordered over the internet, some New York judges will sustain claims against them. There are potentially damages available under New York statutes, unlike under the ADA, which provides only for attorney's fees. There's not a lot of case law about that, but it is a threat that everyone needs to be mindful of if you have any possible connection to New York or to California, where, as Melissa can tell you, the requirements under the UNRRA Act are pretty specific and hard to get around.
So maybe, Peter, you could sort of give us an idea of the typical type of lawsuits that exist today. And I think it's, I always talk about, in the early days, it was very much sort of one person suing one company. But today it's, I think the landscape is completely different. I think it's worth people understand that the landscape is different. It's a small handful of plaintiffs going after a large number of companies, and sort of what does that look like and what are the options?
Sure. Well, in New York, there are a number of law firms that devote a good amount of their time to filing these lawsuits. And most of them at this point file their cases in federal court as class actions. They're often, as Jason pointed out, some of the same plaintiffs filing these suits, but they're doing so not just on their own behalf, but on behalf of a class of other visually disabled people. And has not been the case, as far as I'm aware, that any class has ever been certified or even sought to be certified outside of a settlement context in these cases. Typically what happens is the cases get settled sooner than later, usually, but most at some point, and that's done on an individual basis. The reason, plaintiffs' lawyers could probably speak best to the reasons that they bring these cases as class actions, but from the defense point of view, the understanding is that they do so because it helps get the defendants to take the cases seriously. They are concerned that all of a sudden they'll be subject to a nationwide class action. They're familiar perhaps from other types of cases or from hearing about these types of cases that class actions are very time consuming and expensive, and there can be a lot of adverse publicity surrounding them if there is class certification. So that increases their desire to resolve these cases quickly if possible. And the plaintiff's attorneys generally are amenable to settling on an individual basis, assuming that the other terms for settlement can be achieved. And those will ordinarily require some payment for attorney's fees and a promise of remediation. People can be cynical about the motivation of plaintiffs' attorneys in this area, but certainly in all of the cases that I've dealt with, the plaintiffs' attorneys have insisted on remediation so that there is a actual substantive favorable result achieved by virtue of the lawsuit, that there is now going to be a more accessible website or app, as we'll discuss later.
So, and maybe I can jump in here and talk about some of the differences in California, because we actually have seen some of these that have attempted certification for purposes of settlement. And so I think it's important to explain for a moment, in order to settle these class action lawsuits, you have to get court approval. It's typically a multi-month long process. There's a notification process. It becomes very public. Oftentimes you may be asked to do a publication with or from American Federation of the Blind, and in all sorts of notifications, including on your website that says, hey, we have a class action website. Do you want to be part of it? And so there are a couple of districts in California, northern and eastern so far, and I believe there is one pending right now in southern district of California, where just for the purposes of settlement, the class actions have been preliminarily certified. And, but I got to tell you, I personally have not settled any on a class-wide basis because I've got some real concerns about the enforceability of it, the effect of it as it pertains to the unruh damages. And Importantly, do you get bang for your buck as a company when you're settling on a class-wide basis? And I'll tell you, my opinion is that you do not, because in order to settle one of these cases, you really need to, whether it's on a class-wide or an individual basis, you need to remediate your website. If you remediate your website for one plaintiff, you are remediating it for every plaintiff. So there is no benefit in terms of the injunctive relief, because injunctive relief is going to apply to all, right? So long as you're actually meeting the appropriate standards and guidelines. But what does it cost you? It costs you upwards of 10 times, if not more, to settle one of these cases on a class-wide basis. But if you think about it, if your website is compliant, then you are likely to fend off any future actions, and your website will be compliant with a settlement for one. Also, if you do see copycat lawsuits, the chances are you are not going to be seeing 10 of them or more in order to actually make it financially feasible or make it make sense for you. And the vast majority, if not all in some cases, of the settlements in the class action settlements it all goes to attorney's fees. So while in California, there is an attempt to also bind individuals, bind plaintiffs or putative class members to UNRU waivers, I think there's a real problem with that, because under the UNRU Civil Rights Act, which that's the California statute that provides for damages, there needs to be an individualized assessment of harm. There needs to be difficulty, discomfort, or distress suffered by the plaintiff in order to trigger those damages. And so it is not this strict liability automatic damages payment that is triggered when there is a technical non-compliance on a website. So if you think about that, how possibly can you have UNRU damages on a class-wide basis? You cannot make that individualized assessment. So what that means to me is that there may very well be challenges to these claims, to these settlements, once they make their way through the process. But importantly, you settle with one on an individual basis and you remediate your website, you should be in really good shape for any future claims.
That's good, Adrian. It sort of brings us to the next item, which is related, which is where else should you be worried about, not just your website with regard to accessibility? And I bring this up because, you know, we're seeing two trends in particular. One is lawsuits, and I'll get maybe Melissa and Peter to talk about some practicalities of what they see in these lawsuits. But essentially, not just being sued for a website, but being sued for a mobile app. That probably makes complete sense in terms of how important apps are, right? 92%, I think, of people's time on a mobile phone is used up in an app. That's exactly the same for the disability community. So it makes sense that apps are as important to the disability community as they are websites. But I think it's also important what Melissa talks about. When companies have settled in the past, they're typically settling with one individual for one digital property, being the website. And it's actually possible for that individual to then actually start another lawsuit for the app. We see that actually, I think around over 50% of the companies that get app lawsuits have had previously a web lawsuit. So when a company's thinking about its strategy to make sure it becomes compliant and reduce their risk, they should be looking beyond just the website. So apps are in play, and also now we're seeing video in play. So if you have video content, making sure that that's captioned and can't be used in a lawsuit. So maybe Peter and Melissa, you could talk about those two trends that you may have seen as well.
Well, I'm happy to jump in. There's a couple of points there. We do try in all of our cases to include both website and apps we have not been as aggressive in including video, but that's something that certainly needs to be on everyone's radar. We've defended a number of cases where there is substantive video on company websites that either advertises a product or provides some information, and those do need to be closed captioned, and people sue for that. Usually not the same people who are bringing the lawsuits for visual accessibility, but whatever a company that's unlucky enough to have been sued can do to prevent lawsuit 2 and 3, they should do, and try to include a very broad protection against any kind of similar ADA claim for all digital products and services is definitely the way to go. This might be an appropriate point to mention that what I try to do in our New York federal cases in settling is to have a consent decree signed by the court. There is a big problem in this area of copycat lawsuits, as has been mentioned. And I warn all clients that just because we're resolving the particular lawsuit at hand doesn't mean that you're not going to hear from others, potentially in the same jurisdiction, but potentially in other jurisdictions. If you get sued in New York, you're likely to get a claim letter in California. You might probably get one from Pennsylvania or Florida as well. And I've had multiple clients who've experienced that in all of those jurisdictions. Some, as many as 4 or 5 times. Others were typically just 1 or 2 additional times. And it's our view that a consent decree provides better protection than a private settlement in this connection. There was a case decided a couple of years ago, also by the 11th Circuit, called Haynes versus Hooters, in which the court held that a private settlement is no bar to a copycat suit. So I've taken that to mean that if you have something better than a private settlement, that may be a good bar for a copycat suit. That's why we have the consent decree, under which the court that issues the decree basically retains jurisdiction over the matter for 3 years or so. The company has a period of time to achieve its remediation and compliance with the ADA, and if a copycat comes along, arguably they have to go back to that judge and explain why they should be allowed to assert their claim, notwithstanding that the relief that they'd be seeking, which is primarily an injunction to induce ADA compliance, has already been achieved by the first plaintiff. I have had some pushback on that notion, in particular in Pennsylvania, one attorney who insists that only a consent decree issued after a class has been certified is an actual bar on any copycats. And I understand where that attorney is coming from, but I don't think he's right. We almost came to the point of having that issue have to be litigated via motion recently, but we managed to resolve the issue. So one of these days that may be something that you'll see, and we'll know whether consent decrees are as effective as I hope they are.
And I'll mention for just a moment, because I'm seeing a lot of comments in the chat and the Q&A about whether we're dealing with only individuals with visual impairments. And the answer is no. You see that here it says in 2021, there's a rise in video accessibility lawsuits. Those are typically brought by individuals who are deaf or hard of hearing. And we see quite a few of those in California. They're typically being filed in state court. I think that's just these particular plaintiffs' attorneys' selected forum. And the purpose is to make sure that there's captions with any video content. But the litigation of them is very similar. You still, in California, want to make that assessment in terms of litigation, not in terms of compliance, but whether or not that lack of captioning for that particular video that was on the website affected the usability for the plaintiff bringing the suit.
And maybe we the next area, which I think is, really practical on the ground stuff, Peter and Melissa, is the next slide really allows you guys to tell us what is the practical steps. I mean, what type of advice do you give? What type of roadmap do you sort of picture or present to a company that gets a lawsuit? What's your initial sort of meeting like, and sort of what are the subjects you talk about, and what do you sort of lay out for them in terms of what's going to happen?
Sure. So I'll take this to start. One of the first things that I say to all clients is, have you had your website evaluated for accessibility? I have several clients who come to me with a demand letter and have never heard of WCAG, have never heard of website accessibility, have no real concept of that. I have other clients who come to me and say, listen, we just recently updated our website. We think we're compliant. We don't know how this could have happened. But number one for me, regardless of how it is that we are going to handle the demand or the case, is make sure you're compliant. There are some demand letters that have a little bit more value to them than others, but there is no difference in terms of making sure compliance is number one. You got to decide, a company has to decide whether or not they want to litigate the case or they want to settle the case. And of course, a lot of that is that assessment is going to be based on what is the cost of defense versus what the cost to settle is. And there's this nice little sweet spot where the cost of defense might very well exceed the cost of settlement, or if the settlement's going to exceed the cost of defense, you might want to consider defending it. And obviously that depends on whether or not we've got some viable arguments, which we really do sometimes. We have here remediation if required. My thought is you always want to make sure that the website is compliant, because not just for purposes of litigation, but you want to make sure that you have all of your users who are able to effectively use it. But compliance and accessibility is really a very different assessment than whether or not the particular plaintiff who has filed the claim has standing to sue, has encountered an actual barrier to their accessibility. And so that's going to be part of the assessment in determining how we want to proceed. There are some insurance carriers that cover this. They typically do not. I've never seen a case where the insurance coverage will cover the remediation, but sometimes there's coverage for either cost of defense or for settlement. But I'll tell you, a lot of times the self-insured retentions or the deductibles are really higher than that for which we could settle, or that for which we can litigate a case to a successful resolution. But those are some of the things that we discuss. Peter might have some more to add from his end.
Yeah, the point I would add is the conversation I usually have with the client focuses on not only what I would charge to defend the case through completion, but what happens if they go that route and they're unsuccessful, because then they've paid me tens of thousands of dollars to defend the lawsuit. And if they are unable to prove that their website is perfect, which of course is difficult to prove, they then are exposed to legal fees that the plaintiffs can recover under the ADA and the UNRACT and every other similar statute out there. And that again is going to be another tens of thousands of dollars. So if you're looking at the choice between a defense that may or may not succeed and will potentially cost $100,000 or more, and a settlement which you can achieve right from the get-go of much less than that, most clients opt not to gamble and will opt for the settlement route. One of the other issues we confront about this is the ambiguity as to what really is compliance. In every case that I've seen, the plaintiff has always done some legwork and has a report or some results that will show why, using the software that they use, the website has problems. Your clients or your company's own internal or consultants' viewpoints may be, oh, we looked at the website, we ran tests using various methods, everything seems fine, and that may generally be true, but there may be other issues that just weren't spotted by the software that was being used. That test may be outmoded, or it may be that the software that the plaintiff is using is not the best software, or that some of the results that they're achieving are not ones that really impact the usability of the website. There may be broken links that don't really mean anything. They may not really present any barrier to the visually disabled person using the website with their screen reader software. And unfortunately, in those situations, it's often an agreement to disagree situation, and arguably the plaintiffs have the advantage in that situation, because if you go to a judge and say, hey, our website's a work of art, it's perfect, and plaintiff comes back and says, here's 7 reasons why that's not the case, the judge is likely to throw up his or her hands and say, I'm not an expert on what constitutes compliance with the ADA. And even though there are no regulations under the ADA, no standards adopted by the Justice Department, unfortunately, there seems to be a cause of action, so we'll figure it out as we go along. And then you're stuck defending that case and exposed to the measure of legal fees that I mentioned, as a potential exposure of the plaintiff's attorney's fees.
And I want to note something about California. So in California, although, we've got the Unruh Civil Rights Act, but I will tell you that the cost of defense generally in California is significantly less. And I'm not saying every case is the right case to defend, but I do want to note that we're not typically challenging, when we're defending these cases, we're not typically challenging compliance. We are challenging the particular plaintiff. And so if you have, there is no tester standing under the Unruh Act. So, if somebody did not have an actual intent to use the business or the website, and they were just looking to see whether or not it was compliant, that does not trigger Unruh damages. So that's sort of the way that we get about it. There are different bases upon which we can also challenge these cases. I'll note that if you were accessing the website outside of California, even if it's a website that does business in California, there is no Unruh standing. So just want to give a little bit of light out there for litigation purposes.
Yeah, and actually, you guys have really covered this subject well. I mean, when people start hearing about this, they're like, "Oh, this," it seems like there's not a lot of options. There's not good options. There's options where you can spend lots of money, defending yourself, or spend lots of money, or maybe a little bit less settling. Like that sort of is the sort of options out there. And actually, the next 2 slides that we had, I think you guys covered, like the insurance options. I think everyone should look at what insurance they've got. But I think Melissa's point being is most insurance policy are written in a way that essentially aren't going to help you in the sort of numbers that these lawsuits are costing, because they have deductibles which are basically more than what it's going to cost you to settle anyway. So it comes down to, a lot of the time, understanding and making sure that you reduce your risk. So I actually just want to move to the sort of what our class is, the final practical slide, where you know, if we go to here, because also I want to be conscious of the time. We've got like 15 minutes left, and we want to take as many questions as we can. But I think I just want to sort of give people a picture of what is happening on the plaintiff side. And based on that picture, you could have a practical approach to try to make sure that you don't get a lawsuit or you don't get a demand letter. And this isn't comprehensive, but just to give you an idea, you know, we did talk about the fact that this is primarily very active plaintiffs and very active plaintiff firms. It is a process. They typically will start with a list of websites in a particular industry. They will probably get the plaintiff, who is typically blind or low vision, to go quickly, go do one of the main things on each of the website and find out whether they've got a problem that they could document. This is why you'll see a lot of quote unquote e-tail or e-commerce sites that are targeted, because it's easier for a plaintiff to go to a site that's very similar, 20 different sites. Could I pick a product, add it to cart, check out? Did I have a problem? If I had a problem, could I document it? Can I take a screenshot of it? Can I describe what the problem is? The second thing that probably happens, which we're pretty sure of, is that inside the law firm, there's probably an assistant that would scan the top pages of that website with popular automatic scanning tools to find what we class as little problems, but they can list lots and lots of little problems, which is, you know, what Peter talked about in terms of a list of we know you've got these problems, right? So missing alt tags, missing labels, missing headers. These are all things which most websites have, they have these little issues, but they're easy to clean up. And I would not imagine that a plaintiff and a plaintiff firm spending much more than a couple of hours deciding which issues they're going to put in a claim, and which sites out of the 20 they tried today they're going to put on their list to target. So, you know, it is reasonable to think, hey, let's go do what the plaintiff firms do. Hire a blind person, make sure that they can complete the main user tasks on your website. Do some early scans of your app, of your website, of your you know, of your videos. Do an inventory, scan them, find all the problems, get your team to fix all those problems. Be in a better place, both accessibility wise and legal risk wise, quite quickly. And that's our typical, you know, if a company comes to us, that is what we say you should be doing for the next 2 or 3 weeks. This is what you should be doing. It will put you in a better place from an accessibility point of view. You'll know whether your website can be used by someone who's blind, or if there's a problem. That's going to motivate your staff to know where the real problems are. And you're going to be a lot less visible to the plaintiff firms. And that's really what I wanted to finish with. Like, there's a lot of practical steps you can make right now to make your site more accessible quite quickly and reduce your risk. I am not saying that will eliminate your risk, because probably Peter and Melissa know some companies have been sued, even if they've done lots and lots of work on accessibility. But it will significantly reduce your risk in our experience. So Peter and Melissa, I think we want to move to questions. I really want, Bethany's going to come back in. Love to pick out questions which are going to utilize Melissa and Peter the most, Bethany, because obviously this is, we've got their time on this webinar.
Yeah, so we had one question come in, just looking for a little clarity. And up on the screen, I have put everyone's contact details. So if you have a question after you have our presenters' information, and then I'm able to pull a report of all questions asked through the Q&A box. So if we don't get to your question during this time, I can pull that report and someone can reach out to you. So one of the questions we had is, let's say I have a company in Ohio. We have an e-commerce site. I can be sued in New York or California due to their state laws, even though, let's say in Ohio, they mandated that my site is not needed to be accessible. Just looking for some clarity on the difference in state laws. And
well, I can speak to that for New York. You get sued in New York not really because of the New York state law, or New York City law, which may or may not apply to you in Ohio. I would argue it doesn't, but rather you could get sued there because the theory is that there's jurisdiction in New York because you have an e-commerce site that's selling goods to New Yorkers and they're accessing their website from New York. And it's not the case that in every situation there will be jurisdiction in New York. And in the appropriate case, we challenge that. And I've had at least one plaintiff withdraw a case after I made a motion to dismiss based on the lack of New York jurisdiction. And in other cases, it may enter into settlement discussions. But one of the many reasons that New York is a popular venue for these cases is that New York is receptive to ADA cases, and they take a very expensive view of what their jurisdiction is. So the New York federal courts are likely to find that your Ohio company can be sued in New York federal court if it's doing more than a de minimis amount of business with New Yorkers.
okay. We are seeing some more questions come through. Please keep sending them.
Bethany, I just wanted to make one point just before, because I know we will run out of time probably for all questions, but we do answer all questions. So please don't not put a question in because you think we're running out of time. We'll pull every single question and we'll respond to them even if we don't get to them in this session.
So we have two questions involving AI accessibility solutions or accessibility overlays and widgets. The first is, are there any lawsuits that you know of that involve overlays? And context overlays are minimally effective at best, but I'm curious if the courts have ruled on these at all.
Well, I know there are certainly lawsuits now being filed in which the plaintiffs have pled in some detail about why they believe overlays are insufficient because they're incompatible with screen reader software. I'm not aware of any decision coming down one way or the other on that. That may be some ways off if someone is willing to fight that fight. There's certainly been a lot of attention given in the commentaries and even some of the more widely disseminated media about this whole issue of overlays. And Jason can speak best to the technical aspect of it, but
I mean, rather than talking, I'll talk about the practical aspects of again what we see. We see in lawsuits today features of the widgets or overlays being listed as one of the reasons why the website is not providing equal access. There might be 10 other things that they're pointing out, but they'll add that to the list. I think more practical point of view is that, last week, for example, there was 100 lawsuits across America, and 10 of them were brought against companies who already had a widget or overlay in place. So from a practical perspective, it's not helping avoid lawsuits. I mean, in lots of these cases, part of that feature or function that the widget adds is being highlighted as not an equal feature and being added to a lawsuit. So there's lots of technical reasons why that's the case, but I think from a practical point of view, I think that's more important to understand that they're not going to help you avoid lawsuits, and they're going to add to the plaintiff side in terms of issues that they can point to.
Yeah, someone actually in the Q&A also answered that question as a response. so this would not be an official answer from our presenters, but they said there are private settlement agreements now in which the plaintiff's attorney expressly forbids the use of certain overlays and widgets in the remediation of the website. So that came from one of our attendees in an answer to the last question that we had. Getting a lot of questions here. Has the Biden DOJ taken steps to regulate this area and or adopt WCAG?
Nothing's been done yet, as far as I'm aware. Hope always springs eternal with every new administration that they're going to turn to this, because and I saw one of the questions was what's the litmus test for compliance, and the answer is there is none, and the judges pretty much make it up as they go along because of the absence of Department of Justice regulations. It would be a game changer if they do that. There's some indication the Biden administration is interested in that, but obviously they have a lot of issues on their plate. They're not fully staffed, and whether that'll happen and when remains to be determined. But it's clearly something that needs to happen because the prospects of any change being affected by Congress seem to be pretty doubtful at this point.
Would you say that there is legal value in getting an external accessibility audit after a company has gone through remediation?
Yes, I think there is, because you want to confirm compliance. And I guess it really depends on who it is that did the remediation. But I oftentimes see clients who had their internal IT make updates to their website, believing it's compliant. We run a wave tool over it, and maybe there's 1-2 errors. But I do think it's good to get an external evaluation, a third-party vendor like UsableNet, to come out and take a look at it. And the other thing is the unique issue. One of the primary unique issues with websites is, unlike architectural barriers, it's being changed every day, either because you're adding content or because the manner in which users are using it. So each experience is different. And because of that, I think it's important to have a professional evaluate the website overall to make sure that it is in as good shape as possible.
Yeah, and just if I could just add to Melissa's, what's the audit for? Or for example, we do a lot of work with clients where they didn't build the site and they don't maintain the site. So they want a service that allows them to hold their web agency accountable and know that they're maintaining an accessible website as part of maybe as a contract. But it's important to understand that lots of companies don't build their sites, they don't maintain their sites. So they need to be thinking about this as, well, who's actually building my site? How do I make sure they build it accessible? And how do I make sure it's being maintained accessible? Because the company is the one that's going to get sued, not the web agency.
So that kind of leads me into another question that we have. Are there companies, in your experience, Peter or Melissa, successfully defending accessibility lawsuits based on an accessibility score? And they give the example of like something from an evaluator like Google Lighthouse. So could that work for defense?
So, potentially, but as I said, that's not typically the way that we're going about defending. I mean, if the website doesn't have any violations, then sure. The only, as I just mentioned, the difference though, of course, is that it's dynamic. So maybe you got your accessibility score and you were great, but then you changed content and left out alt tags. So, that's why it so often falls back on what the individual plaintiff's experience was to see whether or not that particular plaintiff has standing.
Yeah, maybe Bethany and Melissa, I think you're talking about this in this way, which is typically the plaintiffs would love to make this about lists of small issues. You've got some, you don't have some, right? A report that says you don't score 100% is playing into the hands of the plaintiffs. The plaintiffs want to say, for you to conform with the ADA, you need to follow every single tick box of the WCAG, which is not true. That there's no such thing in the ADA. So making it more about the individual experience is what you should be focused on. Saying actually, and that's why I say about you should have users who are blind use your website and actually document they can use your website, because then if you get sued by someone who says I've got a blind plaintiff who couldn't check out, you say, well, I've got a blind tester that says they can. It's about what is the purpose of the use of the site and can people do it. A missing alt tag does not necessarily create a barrier for a blind person to purchase a product in most cases, right? So going to a list is actually probably in favor of the plaintiffs as opposed to in favor of the defense.
Yeah, that's great, Jason. We're getting some kind of, I would say, one-off questions about that. Like, does, documents that are on a website, do those need to be accessible? So I think the answer that you just gave puts it really into a nice perspective of to answer some of these other questions that we're getting. We are at the hour, 1 o'clock. So I wanted to thank everyone for attending and note that we do have a survey that will pop up after this webinar. It's just 4 really quick questions, but it helps us know if you found the content valuable. It helps us create future content. It gives feedback to our presenters and organizers. So if you have just another minute to spend, we would appreciate if you could fill that out. Again, it's just 4 questions in a survey. And since we are at 1 o'clock, I think we are going to conclude, but we will pull a report of your questions if we didn't get to them today. And now I'm just going to bring it back to our presenters. Peter, Melissa, Jason, do you have any final thoughts that you want to share before we sign off?
No, as always, just thank everybody for their time, but more significantly, Melissa and Peter, always enjoy doing stuff with you guys, and you bring some great detail to the webinar. Thank you.
Thanks for including us. Happy to do it again.
Great. Okay. So thank you everyone for joining today. We appreciate you being on the webinar and spending this time with us. I'm going to leave the webinar up just for another minute so that you can finish if you're taking notes from the captions. And thank you so much. That's the end of our webinar.